This is for a forecast, 2024 forecast for labor law. Hindi na ako magka-camera para mabilis. Voice over na lang. Let's go. Okay. First question. Josie Laya claimed that her employer illegally terminated her after she refused to sign a new employment contract. She stated that she was a regular employee. In response, Pinicorp argued that Layag was supposed to report to Manpower as a labor-only contractor and suggested that Manpower should be included in the case. Should Manpower be included in the case? The answer is no. Manpower should not be included in the case because they are mere representatives of the actual respondents. It's a consequence of labor-only contracting that the personality of the principal and the contractor is merged into one. Based on the 2021 case of Ortiz versus Forever Richardson. Next question. The Blooms Employee Union and Mamen Electric Cooperative submitted the issue of rank-and-file employees' entitlement to salary adjustment for arbitration before the National Conciliation and Mediation Board. On September 22, 2017, the voluntary arbitrator ruled in favor of the company. The union received the decision on October 3, 2017 and filed a motion for reconsideration, which the arbitrator denied on November 9, 2017. The union received the resolution denying the motion on November 27, 2017 and filed an appeal to the Court of Appeals on December 12, 2017. Was the appeal filed within the period? The answer is yes. The union filed a petition for review within the prescribed period because they have 15 days or until December 12, 2017, within which to perfect an appeal. The 10-day period stated in Article 276 should be understood as a period within which the party adversely affected by the ruling of the voluntary arbitrators or panel of arbitrators may file a motion for reconsideration. Only after the resolution of the motion for reconsideration may the aggrieved party appeal to the CA by filing the petition for review under Rule 43 of the Rules of Court and within 15 days from notice pursuant to Section 4 of Rule 43 based on the 2021 case of Dorelco Employees Union versus Dorelco. Next question. Joe Robles began his career as a line personnel at 23 Electric and became the general manager in 2001. On March 26, 2007, employees of 23 Electric filed an administrative complaint against him, citing issues like nepotism, insubordination, misuse of company resources, and gross incompetence. Robles responded by filing illegal dismissal cases with the labor arbiter, but the court affirmed the National Electrification Administration held jurisdiction over the termination dispute. Before the termination dispute was finalized by the NEA, Robles reached the compulsory retirement age of on August 28, 2013, believing that he was entitled to retirement benefits as per a 2-3 Electric Board resolution. He applied for them but was denied. Then he pursued his claim with the labor arbiter, arguing that he was eligible to receive these benefits. Should Joe Robles' claim be given due course by the labor arbiter? The answer is no. Joe Robles' claim should not be given due course because the labor arbiter does not have any jurisdiction over the case. PD number 269 as amended clearly provides that the NEA has authority to supervise and manage the operations of all electric cooperatives based on the 2022 case of Engineer De La Cruz versus Fibeco. Next question. Slacy was employed as an orthodontist by Biniverse Placement at Ubay Medical in Saudi Arabia under a 2-year contract approved by the Philippine Overseas Employment Administration. After 5 months of employment, her employer requested that she sign a new contract to meet the Ministry of Health requirement for insurance and uniformity. Slacy refused to sign the new contract, suspecting it could change the original terms. After experiencing hostility at work, she resigned. return to her home country and file a labor case against her employer and the agency for contract substitution, should Lacey's action be given due course. Yes, Lacey's action should be given due course because it is contract substitution. Because there is contract substitution. The Labor Code prohibits substitution or alteration of employment contracts to substitute or alter to the prejudice of the worker. Employment contracts approved and verified by DOL from the time of the actual signing thereof by the parties up to and including the period of expiration at the same without approval of the DOL is considered as an act of illegal recruitment under Section 6I of Republic Act number 8042 based on the 2020 case of PhilExpat Placement Agency. Next question. Colette filed a complaint for illegal dismissal and money claims against K Construction and its owner Mika. She claims she performed essential painting work for the company from April 2012 until her termination in November 2014 on various projects. Colette alleges that the company asked her to sign a 3-month labor contract with a clause stating her employment would be renewable based on the evaluations by the site engineer and foreman. She refused to sign the contract, fearing it would undermine her job security. After refusing, the company barred her from entering the construction site. K Construction disputes this claim, arguing that Colette was not a regular employee but was instead hired through a subcontractor for the project. Is Colette a regular employee of K Construction? Answer is yes. Colette is a regular employee of K Construction because her work undertaken is necessary or desirable in the usual business or trade of the employer. Construction is principally engaged in the construction business. K Construction is principally engaged in the construction business. The nature of Colette's job requires her to perform activities which were deemed necessary in the usual business of K Construction. Colette's continuous rehiring to different construction projects of K Construction from April 2012 until her termination in 2014 attests the desirability of her services based on the 2021 case of Laurente versus Helenar Construction. Next question. Mikaya and other employees file a complaint against Ma'am Mendesco, Macolette, Josie, and Ambebe. They allege for unfair labor practices, illegal dismissal, underpayment of salaries, and non-payment of benefits. The employees who work in various roles at the restaurant also claim they face harassment after forming a union. Macolette responded by denying any employment relationship with the complainants. He claimed that Hambebe and Josie are restaurant's owners and that he was only the lessor of the building. To support his claim, Macolette submitted contracts of lease and tax returns showing his income from building rentals. He also provided a certificate of registration of business name, a mayor's permit, a certificate of registration with the Bureau of Internal Revenue, all issued in Hambebe's name. Was Mikaya illegally dismissed by Macolette? Answer is no. Mikaya was not illegally dismissed by Macolette because she is not the employer of the former. Based on the fourfold test, Mikaya, as the lessor of the building, did not participate in the selection of the employees or pay their wages. She did not have the power to hire or dismiss nor exercise control over the work of the complainants. Based on the 2021 case of Salazar versus Simbahon. Next question. Bininet implemented the Bini system, a database listing accredited technical and creative manpower, as well as talents who offer paid services. Workers hired by BiniNet through the Bini system form the BiniNet Bini System Workers Union, or BWO, led by its president, requested a certification election for Bini system workers. BiniNet opposed the request, arguing that no employer-employee relationship existed between the company and Bini system workers. However, the Dole Secretary ruled that an employer-employee relationship was present and approved the petition for a certification election. Is the Dole Secretary correct in determining the existence of an employer-employee relationship in the case? Answer is yes. The Dole Secretary is correct because in a petition for certification election, the goal is to determine which organization will represent the employees in collective bargaining with the employer. The mediator, arbiter, and Secretary of the Department of Labor and Employment have the authority to determine the relationship between the union members and the company. They can make this determination without relying on prior ruling by the NLRC, based on the case of ABS-CBN, IJM Workers Union versus ABS-CBN. Next question. The labor arbiter and the NLRC both determined that Joanna, a seafarer, is fit to work based on the assessment made by the company designated doctor. In contrast, the Court of Appeals ruled that Joanna is unfit to work, citing unemployment as the reason. Can the Supreme Court directly review the facts of the case as Joanna's fitness to work? Answer is no. The Supreme Court cannot directly review the facts of the case as to Anna's fitness to work because the Supreme Court is not a trier of facts. The question of whether the seafarer was properly declared fit to work is one of fact, hence is beyond the ambit of the Supreme Court's jurisdiction in a petition for review on certiorari. Based on the 2021 case of Dole Filman Manning Agency versus Gatchalian. Next question. The Blooms Union and Director Laurenti Jugi submitted for arbitration before the National Conciliation and Mediation Board the issue on whether the rank and file employees are entitled to salary adjustments. On September 22, 2017, the voluntary arbitrator ruled in favor of the company. This decision was received by the union on October 3, 2017. A motion for reconsideration was filed, which was denied on November 9, 2017. A copy of the resolution was received by the union on November 27, 2017. It was only on December 12, 2017 that the union filed an appeal to the Court of Appeals. Was the appeal filed within the period? The answer is yes. The appeal was filed within the period because the 10-day period specified in Article 276 of the Labor Code is for filing a motion for reconsideration following a ruling by the voluntary arbitrators or panel of arbitrators. The aggrieved party must wait for the resolution of this motion before appealing to the Court of Appeals. To appeal, the party should file a petition for review under Rule 43 of the Rules of Court within 15 days from receiving the notice of the motion's resolution, as outlined in Section 4 of Rule 43. Based on the case of Doralco Employees Union versus Don Orestes Romaldes Electric Cooperative. Next question. The engagement letter between Makulet Layag and Mikayo Labog specifies that Mikayo Labog will send Makulet Layag to an on-ground and flight course training, provided that Makulet commits to working for the company for at least 5 years. If Makulet fails to complete this 5-year term, he must reimburse Mikayo Labog for the training expenses with a reduction of 5% per completed quarter of actual service. Makulet resigned due to a dispute with Mikayo Labog's top management and claimed that he was constructively dismissed. Mikayo Labog, in response, filed a complaint against Makulet for wrongful resignation and damages with the NLRC, seeking compensation for the flight training costs since Makulet did not fulfill his contractual obligation. May the NLRC hear the complaint of Mikayo Labog? Answer is no. The NLRC may not hear the complaint of Mikayo because labor tribunals do not have jurisdiction to settle various issues necessitating the application of our civil law on obligations and contracts, based on the case of Esico versus Alpha Land. Next question. Slacy operates Gwen's Sari-Sari store. Mimasor began working as a tindera at the store on April 10, 2010. With a monthly salary of 2,500 pesos. In 2011, her salary increased to 3,000 pesos. In 2012, it rose to 3,500. She worked from 5 a.m. to 12 midnight every day of the week. In November 2012, Lacey instructed Mimasor to take a leave of absence and wait for further instructions. When Mimasor visited the store in February 2013, she discovered that a new tindera had replaced her. Mimasor subsequently filed a complaint alleging illegal dismissal, underpayment of salary, and non-payment of benefits. Will Mimasor's claim prosper? The answer is no, because petitioner's store is a barangay micro business enterprise, as confirmed by her registration on June 24, 2013, and considering further that the discussion on the informality of a sari-sari store operation, the petitioner is exempt from paying minimum wage. Thus, the judgment award should be recomputed as a matter of equity. Workers in the informal sector are no less deserving of protection than those in the formal sector. However, labor tribunals must always find a way to balance the rights and interests of even those that are often overlooked and underserved. It cannot expect a tindahan with minuscule profits to apply the same labor conditions as a multinational corporation. The state's protection should not come at the expense of the impoverishing those who rely on minuscule profits to get by, based on the 2022 case of Cabuos versus Espina. Next question. Bininet signed an agreement with Carrera Corporation where it committed to hiring Joe Robles exclusively as talent for radio and television in exchange for a monthly talent fee and other benefits. Her talent fee was set at 410,000 pesos for the first year and 417 for the second and third years. She also received a signing bonus of 500,000 pesos in Bininet stocks. Bininet barred its talent and regular employees from appearing in commercial ads to maintain the credibility of its news and public affairs program. When Joe Robles appeared in a Rexona commercial, Bininet suspended her for 3 months for violating company rules. Joe then filed a complaint against Bininet for illegal dismissal, illegal suspension, and monetary claims. She argued that she was an employee of Bininet based on the fourfold test. Bininet specifically hired her for her skills, personality, and celebrity status. The company paid her salary through payroll every 10th and 25th of the month, withheld income tax. Bininet suspended her for 3 months without pay under its rules and regulations, and Bininet controlled how she performed her duties as a newscaster, requiring her only to read the news. Is Miss Robles an employee of Bininet? The answer is no. Miss Robles is not an employee of Bininet because she is considered as an independent contractor. There are several factors that may be considered by courts, but the right to control remains a dominant factor in determining whether one is an employee or an independent contractor. Control is the most important element of the employer-employee relationship. Here, Bininet did not control the manner she performs her job as a news anchor, based on the case of Chanco versus ABS-CBN. Next question. Maria Nicolette signed a 2-year employment contract with Maculet Placement Agency as an orthodontist in Saudi Arabia, approved by the POEA. After 5 months on the job, her employer asked her to sign a new contract citing insurance purposes and compliance with Saudi Arabia's Ministry of Health requirements. They assured her that the new contract was for uniformity and would not change the terms of her original agreement. When Maria refused to sign, her employer assigned her to additional duties and forced her to leave her accommodation. They also harassed and embarrassed her in front of colleagues and patients. The hostile environment led Maria to leave her job and return to the Philippines. She then filed a labor complaint against her employer in Maculet Placement Agency for constructive dismissal. Will her claim be given due course? Answer is yes, her claim will be given due course because she was constructively dismissed. The employee is considered to have been illegally terminated because he or she is forced to relinquish the job due to the employer's unfair or unreasonable treatment. The test of constructive dismissal is whether a reasonable person in the employee's position would have felt compelled to give up his position under the circumstances, based on the case of PhilExat Placement versus Kodal Lee. Next question. Coach Mickey filed a complaint against Yves Moving for illegal dismissal, claiming that he was wrongfully terminated from his role as Assistant Vice President for Mining Services due to alleged poor performance. Yves Moving countered, citing instances of neglect and inefficiency. backed by a performance evaluation and memoranda. Coach Mickey contested these claims, arguing that his termination was only communicated to him by his immediate supervisor at the mining site and that US Moving failed to provide the required notices. Was there proper notices? The answer is no, there was no proper notice because the two-notice rule was not observed. Under Article 292B of the Labor Code, the first notice must contain the reason for the termination, affording the employee ample opportunity to be heard and defend himself with the assistance of a representative or if he so desires. The second notice must indicate that there are no grounds to justify the employee's terminations. Again, the second notice must indicate that there are grounds to justify the employee's termination upon due consideration of all circumstances based on the case of Manrique versus Delta Earth Moving. Next question. Aya was hired by the bank as an accounting specialist. The bank fired her for marrying a co-worker, citing their no spouse employment policy. The bank provided no additional reason for her termination beyond this policy, and her husband retained his employment. Was the bank's decision to dismiss Aya justified by its no spouse employment policy? The answer is no. The bank's decision to dismiss Aya is not justified because the no spouse qualification is not reasonably related to the bank's essential operations of its business. Moreover, there's no factual basis to conclude that all of their employees who marry each other would be unable to perform their duties, entailing one's dismissal. Based on the case of Cruz Gagampan versus One Network. Next question. Bini State U hired Malaya as a part-time faculty member under a 6-month service contract. The contract specified that no employer-employee relationship existed. Her service would not count as government service. She would not receive benefits available to regular Bini State U employees, and the contract was not subject to civil service laws. Malaya's contract was renewed 5 times, extending over 2 years and 6 months. After this period, she was appointed as Assistant Professor 3 and held this permanent position until her retirement. Upon retirement, Malaya requested to have her 2 years and 6 months as part-time service credited towards her 15 years of government service required under Section 13 of RA 8291, also known as the Revised Government Insurance Act of 1997, to qualify for benefits. Could Malaya's part-time service at CSU or BNU be accredited as government service, which would allow her to qualify for government retirement benefits? The answer is no. Those who have already retired may no longer request for accreditation under Section 100 of Rule 21 of Revised Rules on Administrative Cases in Civil Service, or the RACS. While the fourfold test may aid in ascertaining the relationship between the government and its supposed employees, it is the special and civil service laws, rules, and regulations which primarily determine the relationship between them. Based on the 2022 case of CSC versus Anang. Thank you.